Hi everyone, welcome to Live with Lori. Welcome back. I hope you guys have been enjoying the lives and tuning in every week and watching the replays and hopefully liking and sharing. So thank you so much for joining us. So as you can see from the flyer, today's topic is going to be about wills versus trusts. So hi Lori, how are you?
Hi, I'm good. How are you?
Good. Okay, so let's get started. What made you want to choose this topic? Why did you? Wills and trusts.
Well, because I think that this topic is something that people always have confusion on. Whether it's professionals or whether it's clients, this is a subject that there are a lot of misunderstandings and misconceptions about. So
Yes. Perfect. Okay, so let's get started. First question, what are the main differences between a will and a trust, and when would you recommend one over the other?
So there are actually a lot of differences, but a very important difference is with a will, you are not transferring things during your lifetime. You're transferring them after your death, and you are doing it after a probate proceeding. So once you pass away, your will has to be probated, and that involves some legal fees. It involves a court proceeding. It involves some time, a considerable amount of time, especially here in New York. And the will, of course, is a public document. It gets submitted into probate. And a trust, on the other hand, you transfer your assets to a trust during your lifetime. Right now, you would make your transfers to the trust. You appoint a trustee to handle your assets, and then upon your death, those assets will get distributed by your trustee according to the provisions of the trust. So if you're saying, I leave everything to my daughter and my son equally, then your trustee will go about transferring everything to your daughter and your son after you pass away. It's private, out of court kind of thing. There are other differences too, but let me hear some more questions and maybe you'll get me right into them.
Okay, so the next question is talking about misconceptions, or do you want to get into probate? Explaining what that is. Which one you think first?
Misconceptions.
Yeah, you like that? Okay. So what are some common misconceptions people have about estate planning? And for question number one, did you say which one you would recommend, one over the other in terms of will versus trust?
Almost always I'd recommend a trust.
Okay.
There might be some exceptions.
Got it. Okay, so
but
yeah,
generally a trust is going to serve a person better.
Got it. So yeah, some common misconceptions about estate planning.
I'll tell you the one big misconception, and I hear it over and over and over and over again, no matter how long I live. A lot of people, including professionals, believe that if I do a will, I'm avoiding probate. If I did a will and I said where I want my assets to go, then my family's not going to have to go into probate and go through that process. That is 100% incorrect. If you do a will, when you die, your family, your beneficiaries, your executor must probate your will. So that's a huge misconception. So
anything else you can think?
I mean, I find myself clearing that one up all the time.
Yeah.
So that's really a big one.
Yeah, and I think that's why I love having these lives and you guys sending in your questions, because I think just as estate planning, estate planning attorney, elder law overall, it's a lot of misconceptions. Even you writing your book about Medicaid and home care and all of that, I think it's super important to be informative because people just don't know.
It's funny. I am in the misconception business because, I mean, the
myths and the
there's
mistruths.
So many misconceptions
Yes.
in these practice areas. So,
or even when you talk about some people try to do their own paperwork, like they try to do their own power of attorney, or they try to maybe their own will, their own trust, and not realizing that you're not, or trying to do applications and
right. A lot of guardianship proceedings have to happen because people went online and did their own power of attorney, because there are certain things that when we get a little bit older we have to do differently, and one of those things is if we're doing our estate planning, we have to plan for what if someone has to take assets out of my name. Now that's not something that younger people are really thinking about. You go on, you do your basic power of attorney. It lets a person have access to your bank records, pay your bills, blah, blah, blah. But it doesn't let them remove assets from your name.
yes.
So that's something that people get wrong all the time. No reason they would know that other than if they've, had an opportunity to think it through with someone.
Got it. Okay, so how often should individuals review and update their wills and trusts?
So my rule of thumb for that is every 3 years or so. It's not a hard, fast rule, but, the laws change. And if something changes in your family,
Life happens.
yeah, you want to revisit your plan. If there's a new child, if somebody passes away, your plan is going to change, and you don't want an unintended consequence. When you die, you want the right people to get the right distributions.
Okay, that actually goes into our next question. What happens if someone dies without a will or trust in place?
Okay, so that's called intestacy. When someone dies without a will or a trust, the statutes of the state that they live in will dictate what happens to their assets. So, similarly to a probate proceeding, let me talk New York terminology.
Yeah, that's what applies to us.
Right, we would probate a will, and if someone dies intestate without a will, you're going to do their next of kin is going to do an administration proceeding, and it's a very similar proceeding. One of the differences being that the intestacy statute says who inherits from you rather than you having said that. So let's say you have a spouse and minor children, for instance. If you had done a will, and you're young, you have minor children. If you had done a will, you probably would have said everything to my spouse, and then if she is no longer here, then you would have set it in trusts for your kids. But if you die intestate, the statute says your spouse gets the first $50,000 and then half of everything else, and the other half goes to your kids equally. Now, do you see a problem with that? The problem with that would be if your kids are minors.
Well, it's kind of what happened to me.
Well,
in my life.
Yeah, exactly.
And I wish I knew you 15 years ago.
And you had an opportunity for that to go wrong.
Yeah. Oh, it went wrong. That's what happened.
Yeah. And
not knowing my rights and,
Yeah, what should have happened
not
is,
a penny.
is you should have gotten half of your mother's estate,
Yes.
minus the first, $50,000
Yeah,
would have
exactly.
gone to Dad. And then he should have done a property guardianship to take in your money.
Yes, that's what was supposed to.
You were a kid.
Yeah, 17,
So,
but then I turned 18, so.
well, that's,
Yeah.
then you were an adult.
Yes.
But yeah, I mean, even if a person has an 18-year-old, but their spouse survives, are they really wanting to leave half of their estate to the 18-year-old? Probably not. They probably would have expected that it goes to their spouse.
Yes.
But the statute doesn't say that.
Yeah.
But, people are not walking around reading the intestacy statute.
Yeah. And it also
so
should
they
be,
don't know
you shouldn't, that the kin, right, I'm kin, should not get anything either, right? So.
Well, it shouldn't have gone that way in your situation because
Yes.
the statute
Exactly.
provided that you
At
get
least
half.
that.
Half minus the 50.
50,000, yes.
But, yeah, planning is good.
Yeah.
Sometimes intestacy gives you the same result as if you had a will. Let's say all you have is a spouse. You do a will, everything to my spouse. You die without a will, everything to your spouse.
Yes.
Sometimes, or if you have 3 kids and no spouse.
And that's for New York.
I'm talking New York. Every state has its own intestacy statute. They're not all the same. And then when you get out of the U.S., they're very, very different. Like some countries have forced inheritance by the kids.
Oh yeah. Do you know?
Even if Croatia for one.
Okay.
Like even if you left everything to your spouse, your children have to inherit. The statutes require your children to be beneficiaries. So, it's different all over the place. But New York is what I can speak to intelligently.
Yeah. And it's always good to just be aware and protect yourself no matter what as an individual, just being aware of our options. And
this is a subject that a lot of people don't like to spend a lot of time thinking about because, it involves death.
Yeah, morbid.
It involves contemplating what happens when I die.
Whereas people superstitious, like, I don't want to talk about it. Why am I talking about it? Because it's going to happen, There's a lot of people
see a lot of that.
Yeah.
You see a lot of that.
Yeah, different cultures.
That's right. And unfortunately, you might leave behind a really big mess with that, with that point of view.
Which you hear a lot too, yeah. Or like leaving a lot of debt, right? Can we talk a little bit about that? Oh.
Well,
kind of.
If you leave a lot of debt and there are no assets, well, okay. Your creditors maybe aren't getting paid.
Yes.
But a lot of trouble that people have when a parent dies and they didn't do any planning is they don't even know where the parents' assets are. Like some people, back in the day when you open an account in such and such a bank, they give you a toaster, and then this bank offers you something else. I've got a lot of people who have like 17 different bank accounts.
Yes.
And the kids have to find them all.
Yeah.
And it's a super pain in the neck.
Yeah, that kind of goes with the master directory that we're gonna start creating
right.
and sending out.
Some people have stock accounts, and some people have stock certificates. As opposed to having an account with like Merrill Lynch or whatever, they have the stock certificates. They just bought the stock, and they've got the stock certificates sitting in their drawer.
Yeah.
So the kids have to go find those. They've got to go into court, do a probate or an administration proceeding, get letters of administration. That takes however long it takes, which is months and months. Then they have to actually fill out a form, go online, transfer those stocks to the whoever the beneficiaries are, or to the estate via the administrator. It's a real pain in the neck.
Got it. Speaking of, you mentioned probate, but you weren't referring to probate. But anyways, the next question is...
If we were talking about without a will,
yes.
I would have meant administration.
Yes,
Very
exactly.
similar proceedings.
Exactly. Okay. So the next question is actually about probate. Can you explain the probate process and why some people try to avoid it?
Yeah. Now, New York is special when it comes to that. It doesn't happen all that fast in New York. Some states can get through probate really quickly. New York, it's kind of a long process. First of all, you get your documents together, your person's death certificate, a paid funeral bill. If the person died with a will, you're going to need the original will. Okay. And then you're going to hire an attorney who's going to prepare a petition for letters testamentary. That's what it's called when you get a certificate appointing you as the executor. The will nominates an executor. I want my daughter to be my executor, but then you have to go in and probate that will, and the court officially appoints the executor. And until such time as that happens, you can't do anything with the assets. They're kind of hanging there in limbo. Like if you have a co-op and you die intestate, or even with a will, your executor has to get through the court proceeding and get those letters issued, get that certificate issued before you could do anything, before she can do anything with that co-op. So that thing might sit empty for, 9 months or a year or whatever the time period is, because in New York anyway, you have to find all of the statutory distributees. That means everyone who would inherit if you died intestate. So who would that be?
Mm-hmm.
All of your kids, your spouse. If any of your kids predeceased you, their kids are distributees. So you'd have to find them, and you would have to either get waivers from them consenting to you becoming the administrator or the executor, or you would have to issue citations to them, and they would have an opportunity to come into court and be heard. So if we can't find one of these people, we may end up hiring a genealogist and doing a search, and if we still can't find them, we might have to ask the court for permission to serve them by publishing notice.
So they do go that far into genealogy and all of that.
Oh yeah. I mean, if you don't have if you don't have access and control of all these people, you're going to have to go looking for them.
Wow.
And I I have an estate that's 3 going on 4 years old. All of her people were in Europe. Can't find them to save our lives. Had to do a publication. It's
wow.
It's just something people don't expect to have to deal with.
Yes.
So
that's crazy.
And there's money just sitting there.
Yeah.
Literally just sitting there.
And people that, I guess that's kind of like stories where people just randomly have an inheritance or get some lump sum where they have no idea where
they didn't even know the person.
Exactly.
In law school, they used to call them laughing heirs. People who didn't even know the deceased.
No idea. Wow.
But hello.
But we're family. So.
Here, I'm your relative.
Oh my God. That's
so
amazing.
Once we get all that stuff, we get jurisdiction over everybody is what we would call it. Once we get that and the court's satisfied with all the documentation, the court will issue a decree, and then they will issue letters testamentary, or if it's an administration, they'll issue letters of administration. And at that time, the executor or the administrator can open up an estate account, an estate bank account, and then start taking possession of the decedent's assets, putting them into the estate account, and then paying creditors and distributing assets to the beneficiaries.
Got it.
Slow process.
Wow. So I have two more questions, but one I think you just kind of answered. It was about what role does an executor or a trustee play? How should one go about selecting the right person for this role? That's kind of what you went over. Okay.
An executor under a will is the person who would be in charge of bringing in the will, hiring counsel, probating the will. Once the will is through with that, once letters testamentary are issued and the person's actually appointed the executor, then they're going to open the estate account. They're going to be responsible for paying bills, distributing assets. It's kind of the person who manages getting your wishes complied with. Trustee under a trust, I kind of like to think of it like if it's a corporation, like pretend the trust is a corporation. The trustee is the manager. That's the person who is authorized to handle the assets, to write the checks, to make the distributions, to pay the bills, to do whatever has to be done with those trust assets. Now, they don't have unlimited discretion. They must follow the rules of the trust. The trust says what the trustee can do or not do. The trust says who income can be paid to, who principal can be paid to, who inherits when the grantor dies. Mm-hmm. So, they are a fiduciary. They have to follow the rules, but they are the person who, and who to appoint. You want to appoint somebody who
you trust.
Well, yes, who you can trust, but also somebody who who can handle the job.
Mm-hmm.
You know, not everybody is as savvy with dealing with money as everyone else.
Mm-hmm.
You know, maybe someone's better with cooking or artistically.
Yeah, people's strengths, being self-aware of your strengths and weaknesses.
I mean, some people are just better at doing that kind of thing than others. So you know who your people are.
Yes, or you would hope, you know, and then...
No, you would hope.
Or you would hope you would have someone that's responsible.
Yeah, and it doesn't have to be, like, let's say you have 2 kids and they're equally, you know, responsible and savvy. You could appoint them both.
Okay.
You could appoint them both and require that they act together, or that they can act separately. Better separately, because the banks don't seem to like to open accounts with trustees that have to act together now. They only want one person signing things.
Oh, got it.
So, but yeah, so that's how we choose our fiduciary.
Great. So the last question was interesting. It's, are there any specific considerations or strategies for estate planning when it comes to blended families?
Yes. Absolutely.
Yeah, this is a different question because, you know, there's so many blended families now. And
well, you know, you and I both, well, not you really, I. saw the ramifications of not doing special considerations for blended families. So let's say a man's wife dies, he and she had children, then he remarries.
Yes.
Okay. So if he does the standard plan, okay, the typical plan, where, okay, when I die, everything to my wife, and then if she's gone, everything to the kids. Well, okay. So when my wife inherits, then she has every opportunity to do a new will and leave everything to her kids and cut mine out.
Yes.
So a nice mommy or daddy wouldn't want that. You know, most people want their children to inherit even if they've remarried.
Yeah.
Not everyone.
Yes.
Okay.
Yeah.
I mean, every family is different, and there are all kinds
know
of
how you could be persuaded.
Right. There are all different situations, but I know too many cases, only too well.
Yes.
Where
it goes left.
Where the surviving wife of the decedent changed her will and cut, you know, one of his kids out.
Horrible.
It happens. It just
It's
happens.
so
And you know,
sad,
people, when you're talking to the people, they think, oh, I don't think my wife would do that, or I don't think my husband would do that.
You don't know what people would do for money.
Right. It's like amazing. It's really amazing. But yeah, you want to make provisions in your trust. And that's why, you know, trust planning is far superior.
Yes.
You want to make provisions for if you die first. I mean, there are all kinds of things that you could do to make sure that your original children are not cut out. Mm-hmm. But you want to have that conversation, and you want to plan ahead of time. What if this? What if this? What if that?
Yes.
You don't want to leave everything, in my opinion, you don't want to leave everything to your new spouse and trust her or him to not change the plan. Mm-hmm. You just don't.
Yes.
And they could remarry too. And they could be unduly influenced by another spouse.
Mm-hmm. And has nothing to do. It's like so far removed from the original source of, you know, the assets to begin with. And
not everyone has good intentions. And even if they do have good intentions, they may have their own personal reasons for not liking one of your kids.
Yeah, their own, or people have their own beliefs, and
I mean, it could be right or it could be wrong.
Yeah, I mean, I could only imagine, you know, the process you've gone through with clients and how difficult it can be, or even people just being so indecisive or too emotional, you know, and they can't make a decision, or their emotions get involved and they make poor decisions. It's a very
I mean, it's really painful for the adult kids that are left behind. Very, very painful. I mean, even if they don't care so much about the money,
it's the principle.
They always care that they've been slighted or overlooked or treated unfairly.
Of course. I don't think I've ever heard a perfect scenario. You know, someone always gets offended or hurt. Like, oh, why did she get this and I didn't get that? Or why did she get this ring and I didn't get that? You know.
And it's one thing if dad decides, okay, I want this kid to get this and that kid to get that. It's another thing if his new wife decides.
Yes.
You know,
it's like, who are you?
gee, this one will be cut out. Yeah, no.
Horrible.
So, yeah, no, these are things that have to be thought through. I mean, if you have a blended family, you owe it to everyone involved to make a plan.
And do what's right in the end, you know. But that can mean anything to
Well,
anyone.
right. I mean, you know, you can do what you want to do, but consider it.
Yes.
You know?
Consider trying to do the right thing.
Yeah.
Or what's fair, you know. Great. Okay, so, you know, we always like to end with a little fun. And I know you guys love these little this or that or would you rathers on social media. But yeah, we have a few minutes left. Do you want to do a few this or that? Some cute fun.
Sure. Why not? Why not? This or that.
I know you love games.
This or that.
This or that.
I'm a mom. I've heard this or that games before.
And would you rather, right? Okay, so this or that for a trust. A revocable trust or irrevocable trust?
It depends.
Okay, you could elaborate a little bit. We have a few minutes.
Yeah,
we have another 5 minutes or so.
So that's actually a good this or that question.
You like this one.
if you're younger and you want complete control over your assets and you don't want to have anyone else signing off on anything but you're going to be likely to want a revocable trust. A revocable trust will avoid probate, so when you die, your assets will pass through the trust. They won't have to go into court. If you are older, and that's an individual term, if you're older, if you want protection, if you want those assets to be protected so that if you need, God forbid, nursing home, or if you need home health aides, and you're concerned about running through your assets and you want your assets out of your name, then you're going to think more about an irrevocable trust.
Got it.
What we usually do is a Medicaid asset protection trust, which is kind of a hybrid between revocable and irrevocable.
Okay.
But yeah, it depends completely on your circumstances, your health, and your age.
Perfect.
You know, even if you're young, if you're in very poor health, if you have, you know, a disease or whatever, you may need to go with an irrevocable. You may need to protect those assets so that you can receive Medicaid to pay for some very expensive health related bills or something.
Perfect. So for the executor, family member or a professional executor?
Depends. I think most people prefer a family member if they have kids who are responsible, trustworthy,
yes,
get along. If not, an independent is a good option. You could pick a sibling. Well, that's a family member, but you could pick, you know, a sibling as opposed to your kids. You want to try to pick someone who is likely to outlive you. You don't want to pick like your older sibling or your parent or something like that.
Yes.
You want to pick preferably someone in the next generation. But if, you know, some people pick a friend. Some people actually ask an independent fiduciary to be their executor. That's also a thing.
Okay, and that would be like a professional?
Yeah, there are people who will
Not
do this for money, who will step in and handle your trust for you. Some people don't have family members or friends. Like,
yes.
You know, or like if I'm 90 and all my friends are, you know, in their 90s, that's not a good choice. First of all, I don't want to saddle a 90-year-old with that.
Exactly.
And second of all, I could outlive them. So you want to pick someone who's likely to be able to be there and handle the situation.
Yeah, pretty much family first and then professional. It's more if needed.
Yeah.
Okay.
And again, very individual, personal choice.
Got it. So the next this or that question, which you already answered, was for the review annual or every 5 years. You said kind of in between at a 3-year mark.
I mean, I like the 3-year number, not for any particular reason other than there's been enough time that maybe there are changes in the law, maybe there are family changes, maybe someone was born, maybe someone died, maybe you just want to refresh yourself on what your plan is and see if you want to make any changes. So I kind of like that time frame. Yeah.
Got it. So this is interesting for charitable giving. What do you think of a percentage of a donation of your, I guess, assets or your estate, or a charitable trust?
Oh, that's that's not really much of an either or. It really depends on what your purposes are. If you're just Mrs. Jones, you're a widow, you have a modest estate, but you want to make sure that the Catholic Charities gets something, or that St. Jude's or whatever, then you're going to leave more than likely a percentage. You can leave, like I see a lot of people leaving like, okay, $10,000 to this charity, $10,000 to that charity, and then everything else they're dividing up between their kids.
Okay.
Because the $10,000 is not the bulk of their estate.
Got it.
Right?
That actually goes into the next this or that. Equally distributed or customized, like a customized distribution. So it's kind of
totally
not one or the other.
person.
Yeah.
Well, so here are the considerations that I hear a lot. Some people have children of various ages, right? Like maybe they have some older kids, then maybe they remarried and they've got some much younger kids.
Yeah.
And they think, well, the older kids are settled, they have their homes, they have a lot of, they're situated just fine, but this kid's just starting out, so I want to make sure that this kid's cared for.
Yeah, customized. Or even like the older children have their own families, grandkids are involved. It's just, so it's all kind of what...
So it really just totally depends. Other people will go even Steven across the board no matter what. I mean, you see it every which way, and there's really no right or wrong. I find that people really... Not everyone comes in knowing exactly what they want to do, so, you might offer some suggestions. A lot of people come in saying, I know that this young kid that I had in my, second phase of child rearing,
yes,
this kid is likely to be, just starting out when I pass away, and I don't want to leave him flapping in the wind.
Got it.
So I see that a lot.
Yeah. We actually got a comment from Yasmin. She said, great information. I'm glad you're liking it.
Thank you.
Yes. So, I think that's it. We touched on so much. Anything else? Any last words about wills and trusts? And
there are no last words. I could go on and on and on. Unless,
we could do a part 2, 3, 4, 5, 6.
Right. But it's a big subject.
Yeah. Well, thank you so much. Thank you guys for tuning in.
Yes, thank you.
We will see you next week. And I hope you enjoyed. Please like, comment, share. I always want to say subscribe, but you can go to our YouTube and search NY Elder Law Group and subscribe over there. We have a last question. Amy, Insurance NY, said, I love it. I actually am studying for my LSATs to go to law school and plan to work in estate planning. Hi, Amy. Yeah, definitely reach out to us, DM us, comment, and we can.
Good field. It's a good field to get into.
Yes, estate planning.
As law goes.
Yes. And go back to our clips at the beginning of when we started posting a couple months ago, and Lori talks about her experience of what made her get into estate planning and elder law. Feel free to comment and DM us, and we can chat with you a little more from there. But thank you so much for tuning in.
Good luck on the LSATs.
Yes, good luck, Amy.
You'll kill it.
Thank you. Thank you, guys. See you next week. Bye.